Away from that, the Court of Appeal in Abuja has established a special three-member panel to address political cases from Rivers State, with hearings set to commence on Thursday, November 14. This development follows rising legal disputes due to tensions between Governor Siminalayi Fubara and his predecessor, Nyesom Wike, now the Minister of the Federal Capital Territory. The feud has sparked a wave of legal actions within the state, causing divisions among political actors and resulting in contradictory rulings from courts of equal jurisdiction issues that has prompted concern from both judicial stakeholders and the public. To bring order to these proceedings, Court of Appeal President Justice Monica Dongban-Mensem has appointed the panel to manage all appeals linked to the political crisis in Rivers State. To help make sense of this, we're joined now by legal practitioner Henry Ekine. Henry, it's good to have you on the news. The establishment of this panel, from what we have, aims to provide a clear and expedited resolution to the political disputes. How will this panel do this?
Well, thank you. I think for me, it's commendable to demonstrate the commitments of the judiciary, particularly the Court of Appeal, to be clearly focused on the avoidable political crisis in Rivers State. That's for the first consideration. I think for me, this clear demonstration of the concern, I would say, that Rivers indigents and residents have expressed and deep worries about how the judiciary has handled it. So that's one. But clearly, whether this will make any change or any difference in what the issues are, I think we're going to watch and then see what the outcomes of the hearings and then the decisions in the respective appeals would be. Because to the best of my knowledge, at the last count, one of the matters, fortunately I was in Abuja in the Court of Appeal, there were about 13 cases already before the Court of Appeal, if there are not more at this moment. So to have constituted a panel, a special panel that will be focused on considering all of these appeals and then making informed and decisive decisions with the issues that are surrounding the contestations in the Rivers State House of Assembly, principally, I think that's commendable. But what's for me is a concern. Yes, please.
Go ahead, conclude your thoughts.
Yes. So what for me is a concern is whether the judiciary will be upright and then very deliberate to address the critical remote issue of Section 109, subsection 1, paragraph G of the Constitution of the Federal Republic of Nigeria, considering that the Supreme Court of Nigeria has made pronouncement with respect to that provision of the Constitution and then the clear effects of defection. Because in all consideration, that is the crux of the matter. That is the remote cause of all of the issues that arose eventually and all the litigations in the respective high courts, the state high court and the federal high court that had got to the appeals before the Court of Appeal. So if we get this panel to be able to put together all the concerns and all the agitations, and then be frontal, to be very clear on that particular issue, I think we'll address a whole lot of these questions that have really been asked and then have been debated across the country with respect to the political crisis in Rivers State.
Henry, this crisis seems to have defied all logic, has defied mediation, has defied legal issues. How will this panel streamline resolutions of disputes that already have court rulings on them? That's on the one hand. One fine thing you mentioned is, yes, it's not a bad thing, but their strength will be in their implementation. The president spoke on this crisis, but there doesn't seem to be implementation of resolutions made in a way to resolve the crisis in Rivers.
Yeah, for instance, I had said at some point that the issues that were central in the political crisis in Rivers State were constitutional and were legal. not just legal, but fundamentally constitutional. And when there are constitutional issues, I argued earlier that they are not to be resolved by some political solution, but clearly judicial interpretation of the provisions of our Constitution. Every citizen of the Federal Republic of Nigeria and every authority, including Mr. President, including the Chief Justice of Nigeria, including the governors of the state, including the judiciary, and citizens are under obligation to uphold the provisions of the Constitution, to defend the Constitution, and the judiciary to interpret matters before them, determine matters before them, just as it is by the Constitution. So when the issues arose about the defection of 27 members, former members of the River State House of Assembly, on the 11th of December 2023, and then fundamentally, the remaining members of the House of Assembly elected for themselves a speaker, and that speaker, pursuant to Section 109, subsection 2, made a declaration of the seats of those former members who had defected from the People's Democratic Party to the All Progressives Congress as vacant, and communicated the Independent National Electoral Commission, also an executive body established by the Constitution, Section 153 thereof, to conduct elections to fill those positions. For me, that was the climax of the political crisis in Rivers State. And then we failed, both the commission, INEC, failing to conduct the elections within the 90-day window, and then the judiciary, at the stages we had those matters, maybe the State High Court and the Federal High Court, the issues of jurisdiction, and then conflicting decisions.
Yeah, but Henry, you still haven't answered the question about how this panel, implementation, that is where the problem is. This panel might come up with a finding. What are the chances that they will be implemented? In the interest of time as well, I'm going to squeeze in this question. What gives you hope that this panel will work? Is there a precedent here that we can pick from? Have we had such a panel before? Did they accomplish their goal?
Yes, but I think let me clear perhaps a perception. It is not anything outside of the proper Court of Appeal and then the jurisdiction of the Court of Appeal to entertain appeals from the lower court, that's the High Court, that they are referred to a special panel. It didn't mean or suggest probably some sort of a commission for inquiry or anything to give a report. The Court of Appeal and the justices, the three of them, are sitting as justices of the Court of Appeal, sitting on appeal on those judgments that have been brought before them from the trial court. So the outcomes will be a decision, will be a judgment of court. So they will be enforceable as any other judgment of the Court of Appeal. And if anybody is dissatisfied, it's still appealable. It didn't mean that because the president of the Court of Appeal has constituted this special panel. I think the purpose sometimes when panels are constituted for special purposes is to expedite the process and to make them focus on just those matters. So it will suggest that these three justices will not be attending to any other general matters that were before them, but to be focused on these River State appeals, all of them. Like I said, at the last count when I was in the Court of Appeal on one of the matters, they were both 13. So they have to focus on all of them, for deliberate focus on them, give time, and consider dispassionately the outcomes of these decisions. And again, being decisions of the Court of Appeal, if anybody is dissatisfied, it's appealable to the Supreme Court. It's not such a special panel that would have considered themselves to be final. So the possibility of the outcome is like the possibility of any judgment of the Court of Appeal, and it's also appealable.
Henry,
enjoying that, I think we should have an end to all of the litigations in Rivers State. That would be my prayer.
Thank you very much for the clarification. That was important. Thank you for speaking with us as well.
And thank you for having me. It's always my pleasure to be with you, Felicity.